One of the most common questions I get is whether or not an executor has to show a will to a beneficiary and other heirs. The short answer to that is no. The executor holding the will during a person's lifetime certainly doesn't have to show it to anyone. In fact, it's probably better if people are unaware of the contents of a will until after the decedent has passed away. Once the decedent passes away, the person holding the will has a specified time under Georgia law where they're supposed to file the will with the probate court. Once the will is on file with the probate court, typically the heirs and beneficiaries are able to go to the probate court and see a copy of the will. What's going to follow after that is the executor will file a petition to probate the will, and all the heirs will be notified and served with a copy of the petition and the will. Another safeguard for beneficiaries under a will is a new law that Georgia passed in July 23. This law requires that an executor, once the will has been probated, is required to contact the beneficiaries under the will by certified mail. The executor has to provide their name, address, and phone number and make the beneficiaries aware that the probate estate has been opened. Once these notices have been provided to the beneficiaries, the executor then has to provide proof of the notices to the probate court. Determining whether or not an executor has broken the law are exactly the type of matters that my firm handles. These are fact-specific inquiries, and they depend on a lot of things, such as where we are in the process, who are the people that believe they should have been notified, and whether or not the executor has been given a reasonable amount of time to perform their duties. If you have questions about the conduct of an executor, contact Peach State Probate. These are exactly the type of matters that we help families with on a daily basis.